Trust beneficiaries may inherit a variety of assets after the death of a loved one. If the deceased person owns stock in a company, the beneficiaries may need help in deciding what to do with inherited stocks. I'm Paul Groh, Director of the Estate Administration Department at the Law Offices of Daniel Hunt. In this video, I'll explain what to do with inherited stock, how to understand the tax liability of this asset, and how to transfer stock post-death. An inherited stock is a stock that an individual inherits after the original equity holder passes away. The deceased either received stock, options from their employer, or they invested in the stock market by purchasing direct shares of company stock. Whichever way the stock was accumulated, their heirs will need to decide what to do with the inherited stock when they pass away. If you are the sole beneficiary of the stock, consider whether you'd like to keep the stock as part of your personal investment portfolio or sell it. If the stock is a high-quality investment and has performed well over the past 10 years or so, it may be appropriate to keep it. If the stock is not a high-quality investment, you may choose to sell it. You may also need to sell the stock and split the proceeds if there are multiple trust beneficiaries so that the proceeds can be divided equally amongst them. If you plan to sell your inherited stock, you need to understand the tax liabilities involved. Here are 3 key points. 1. Any increase in value that occurs while the original stockholder is alive will not be taxed under a step-up in basis value. Let's say your mother purchased 100 shares of Apple stock in 1982. The original sale price was $22 per share for a total of $2,200. She keeps those 100 stocks until her death in January of 2022. By the time of her death, the Apple stock value was $178 per share for a total value of $17,800. The heirs will not owe taxes for capital gains on the increase in value. 2. Inherited stock is valued at the date of inheritance, not the original purchase date. Inherited stock is not valued at its original cost basis, the price at which the owner originally purchased it. When a beneficiary inherits a stock, its cost basis is stepped up to the value of the stock at the date of inheritance. Usually that's the decedent's date of death. The beneficiary inherits the stock with the adjusted basis value, which will be the reported basis value if the beneficiary later sells the stock. 3. Stock heirs can't claim a loss for losses incurred while the original owner was alive. Let's say a decedent purchased a share of stock for $100, but the stock performed poorly. By the time they died, the stock value was only $25. The heirs' cost basis would be $25, and the $75 loss could not be used to offset gains with other investments. Those who inherit stock will need to transfer it into their names. If the original stock owner designated a transfer on death beneficiary for their stock, the beneficiary usually receives those stocks directly upon filing a claim for the transfer. If the stockholder didn't designate a transfer on death beneficiary, then the stock will need to be distributed as part of the decedent's estate. The paperwork required to transfer stock depends on what kind of estate plan the decedent created. If the decedent created a trust, then their successor trustee needs a copy of the decedent's certification of trust to show their authority to transfer ownership. If the decedent only created a will, or didn't have an estate plan and their estate is being probated, then the estate's personal representative will need to secure letters testamentary from the probate court. Or if the total estate value is under the California probate threshold, the estate's personal representative must secure a small estate affidavit. Once the successor trustee or personal representative has obtained the necessary documents, they must send them to a stock transfer agent, who can complete the transfer of ownership. If you have questions about what to do with inherited stocks, please contact our firm. We hope this video has been helpful, and if you have any questions about estate administration, feel free to contact the law offices of Daniel Hunt using the information listed below. Thanks.